Well, welcome to another episode of the Nebraska Way podcast, where it's all about how Nebraska is growing and more. Today, we are going to have a very fun conversation. We got a great guest that's going to be on. That's going to be talking about a lot of the issues that are facing our country today, especially in the legal realm. Kristen Waggoner. And Kristen, you are with the Alliance for Defending Freedom. And well, first of all, you serve as the general counsel for the Alliance for Defending Freedom. And ADF is the largest legal organization that protects religious freedom, free speech, parental rights, and the sanctity of life. Kristen includes an oversight of over 130 attorneys and a staff that engage in litigation, public advocacy, and legislative support. In the past 10 years, ADF has won 13 cases in front of the U.S. Supreme Court, including 2 that Kristen argued, so we're going to get into that in just a little bit. One of those was Masterpiece Cake Shop versus the Colorado Civil Rights Commission, a very important case with regard to people's rights and religious freedom. And the ADF is committed to protecting freedom through an alliance of folks. You enjoy broad support from conservative movement and rely on over 4,000 attorneys in the private practice, the private sector, and over 3,000 organizations as part of the broader alliance to protect freedom in our courtrooms. Kristen, it is great to have you on here in the podcast, and I want to talk a lot about these different cases that you've been involved in, because these are, just hugely important for our country, and obviously have been very topical in the news. But let's take a step back, because I think you went undergrad to Northwest University in Washington State, and then went to law school at Regent University, which is in Virginia Beach, that you also were a law clerk for a Supreme Court justice in Washington State. So why don't we just take us back a little bit. Tell us a little bit about your background, where you grew up, what inspired you to get involved in the law, what inspired you to get involved in defending these freedoms that we have with regard to religious freedom and freedom of speech and so forth. Just, give us a little bit about your background.
Sure. Well, I grew up in a small town in between Portland and Seattle in Washington State. It was called Longview, Washington. And my dad and my mom grew up there as well. All my cousins lived there. Didn't have any lawyers in my family, but my dad, he was at first a public school teacher, and then he moved over to a Christian school and ended up serving as my principal, kindergarten through 12th grade.
Wait, so your dad was your principal going up? There's no pressure there, right?
Oh, there was a lot of pressure, let me tell you. Yeah, there was a lot of pressure, a lot of eyes watching, keeping me in line. And catching me when I got out of line. But he just played a huge role in my life and talked to me a lot about finding the calling that I had in my life, that I was born for a purpose. And I ended up concluding that the reason I was born in terms of vocationally was to pursue a career in law, to protect religious freedom, protect Christian schools, ministries, and free speech.
So now, Kristen, how did you develop that? When did you develop that calling to defend religious freedom and free speech, and know that that's what you want to do? Was that something that you decided on in high school? Was this something that you decided on in college? Was this why you went to law school, or was it something that you developed as you went through law school or after?
Well, it's a little different for me, I think, than a lot of people. I felt it when I was 12 years old. I remember the moment pretty clearly, and it just kind of kept me on track through the future years, of which included, a little bit of rebellion here and there that I could have got really screwed up in, but instead I knew...
Okay, what kind of rebellion are we talking about, Kristen?
I'm not going to tell you that. That's the last thing I'm going to tell you.
It makes you very human, Kristen. It makes you very human.
Well, let's just say when you're in a mill town, there's a lot of trouble you can get into. But it was an idyllic childhood, and my dad just was a real formative influence on my life, continually telling me, I think there's more here, and you need to look at why you're created, and if you're not going to contribute in a way to human flourishing, then you really aren't serving your purpose. And so that's what stirred my soul. And that's what I believed as a person of faith. That's what I believe that God was directing me into. It took a long time, though. I mean, I bet this is true for you as well. It took me down paths I didn't expect, including spending about 16 years in private practice before I came to ADF.
Okay, very good. So talk to me a little bit about that private practice. What did you do before you joined ADF?
I worked at a boutique firm in downtown Seattle for almost 17 years. I started there right after my clerkship. I worked my way through associate status into partner status, and just had the best of friends in that firm. I bridged both sides in terms of transactional work as well as litigation, but got to help a lot of religious organizations in the process. That usually meant employment law, negligence, volunteer law, all the areas that religious organizations can get in trouble in, but then also allowed me to do some First Amendment work. And that eventually led me to coming to ADF.
All right, so yeah, talk about that. So you had a First Amendment case that brought you to the attention of ADF, or that you worked with ADF. How did you make that transition from, because you're on the West Coast, right? And ADF is in DC, right? So,
well, at the time, yes, we have offices all around the world now. But at the time, when I was in law school, for example, ADF had just started. We officially launched in 1994, and I graduated from law school in 97. So it really wasn't a thing quite yet. But I did have friends that came to work here. You mentioned that I went to Regent University, and people may not have heard of Regent University Law School, but that's the only school I applied to because it had a reputation for helping students to understand constitutional law from an originalist perspective, and was particularly strong in First Amendment issues. So now I get to work with those friends, those who came before me and after me here at ADF.
So wait, Kristen, you only applied to one law school, and it was Regent University Law School, just one. Like, what happens if you didn't get in?
Oh, I was getting in. I don't know. I never contemplated that. But I was thrilled with the choice. And it's just been a blessing to be able to work in these areas, both in private practice and now in the public interest.
Okay, so you were doing some First Amendment cases in Seattle. How did you get connected with ADF?
ADF is very innovative in how it approaches these kinds of cases and the work it does. It's the only organization that I know of that really launched through a funding program. So no one organization is capable of protecting our freedoms, not one group, not one constituency. They work in alliance, and they knew that they needed to have as a part of that alliance attorneys in private practice. And yet, those of us in private practice, while we might be able to donate our time pro bono, free of charge, we may have partners or business interests where we need to pay for the paralegal's time or provide compensation to the firm to make up some of those costs. And ADF actually provides a grants program that allows private practice attorneys to engage in this work with their help and have some nominal funding along the way. So that's how I got to know ADF.
So was your law firm then working with ADF on this First Amendment case, and that's how you made the connection there?
Yes, there were different cases that came up over the years while I was at ADF, and they would ask me to help as local counsel. And sometimes I would apply for grants with ADF so that I could litigate as first chair in those cases. One of those cases was the Stormans case, which is a case that was litigated for about 10 years involving pharmacists and pharmacy owner conscience rights. And that was on behalf of a fourth generation family owned business. And so that was the strongest and most significant contribution and connection I had with ADF before I joined.
So what made you decide to join ADF?
Oh, well, I can't say that it was good news, but it was something that I believe God just used in my heart to help kind of untether me from my firm. I remember reading the Windsor decision, which was the first same-sex marriage decision that the U.S. Supreme Court issued, and reading the dissents in that decision, and just realizing as we were being warned by the justices that those who held traditional beliefs about marriage and human sexuality would be facing an onslaught of litigation and likely persecution through the court system because of those decisions, that it wasn't a live and let live any longer. And feeling that angst in my spirit and just really feeling like I was called to be a risk taker. And so, sitting comfortably in a partnership, putting your head down wasn't an option, at least if I wanted to be able to leave a legacy for my kids.
Well, you already demonstrated you were a risk taker by only applying to one law school. So you had that going for you. So did ADF offer a job to you and then you took it? Or did you say, hey, I'd really like to come work for you full time? How'd that work?
I actually had been approached by ADF at different times during the years and had worked with them on different cases. So, I thought that if I'd come to them, and eventually I did. I just said, I'm ready now. Will you take me? And thank God that they did. I don't know if I knew then where we would be now. I don't know if I would have had the courage to do that because things escalated pretty quickly in terms of the legal battles that we're facing. But it has been a wonderful journey.
Well, okay, so let's jump into that. So talk a little bit about some of the legal battles that ADF has taken up, just maybe broadly speaking, to give some of our listeners and viewers a flavor for what ADF does if they're not familiar with them, and then talk about some of the specific cases that you've been involved with.
Sure. Well, we're focused on 5 generational wins. And the reason we call them generational wins is because we believe that we are called to protect freedom for our generation and to hand that freedom to the next. And every generation has that calling. And so we're focused on protecting religious freedom, protecting the sanctity of life, protecting parental rights, protecting marriage and family, and protecting the right to free speech. And we protect those rights not just for those who agree with us, we're a Christian ministry, but we protect those rights for everyone because we all have those God-given rights that are constitutionally protected. So that's a little bit about what we're about. And as you well know, since I joined in 2013, and even a little before then, those particular areas have been in conflict and really in a state of crisis in the law since then. So that has led to a number of Supreme Court cases that we've worked on.
So you mentioned that you take cases for people who don't agree with you. What's an example of somebody like that?
Well, there are lots of examples. We litigate more free speech cases in terms of student rights and students' free speech than any other organization. We file briefs on behalf of, people of faith that don't ascribe to the Christian faith. We represent a number of people that don't agree with us on a whole host of issues. But we all should have the right to free speech. We should all have the right to be able to bring truth into the public arena and to debate that truth. And we should all have the right to be able to speak and live consistent with our core convictions.
So you talked about generational cases, which is, by the way, very Ronald Reagan of you, right? I mean, the whole freedom's not passed on in our bloodstream. It's got to be taught to the next generation. And you're fighting to protect those freedoms for the next generation. What are some of the specific cases that ADF has worked on that really represent those generational type cases?
Well, Dobbs is one of them. That's a case right now pending.
Okay, let's just jump right into Dobbs.
It's hard to
I was going to save that one for a little bit later. But you brought it up. We might as well just jump right in and talk about that now.
I'm happy to do that because I think it's probably the most timely and certainly the biggest case protecting the sanctity of life that we'll have in our generation.
All right, so jump in. So tell us about it.
Okay. Well, essentially, and I think in order to understand what's at issue at Dobbs, you need to know a little bit about Supreme Court jurisprudence. And the reason that it's kind of complex is because the Supreme Court has frankly made it up. There's a web of legal rules that aren't anywhere found in a statute or in the Constitution. They're simply made up by judges.
Well, yeah, let's go back to, if I can interrupt here for a second.
Yeah.
Roe versus Wade was made on some penumbral right of privacy, which I know it's commented oftentimes. You can search through the Constitution till you're blue in the face or whatever. You're not going to find that right in the Constitution. It's not written there. It's not there. Basically, the Supreme Court made that up. Would that be an example of what you're talking about?
It is the exact example that is like the best example that we can have. It's nowhere in the Constitution's text. It's nowhere in its history. It was simply made up by the court. And the Roe decision, which essentially said abortion is a constitutional right, was the first case. And then Casey is the second. And Casey was a second decision that came where the court said, well, we know that Roe basically said the state's interest in protecting life and protecting a woman increases as the baby grows, but they used what's called a trimester framework. And Casey realized that's not really based on science or anything else. So Casey threw out that framework in Roe, but held on to that premise that there is a constitutional right to abortion. And that was decided 30 years ago. So Dobbs is the case that is asking the court to overturn Roe, to overturn Casey, and to return the issue of abortion back to the states where it belongs.
So maybe, again, for our viewers and listeners who are not familiar with the Dobbs case specifically, maybe you can give us a little background about that. Now, this is a case that comes from Mississippi, correct?
It does, yes. So I'm sure your listeners have heard of different laws that have been passed that limit abortion and work to not only protect life, but also protect the interests of the woman. The Supreme Court has said in other decisions that states have an interest in helping to protect women, and it's recognized that there are serious consequences that take place when a woman has an abortion. States also have an interest in protecting life and in protecting the medical profession from engaging in inhumane procedures that really coarsen our society. So Dobbs is essentially in it. I know it gets tangled, but in Casey, when they threw out the framework test, what they said was that states could not limit abortion prior to when a baby is viable outside the mother's womb. And that's called the Viability Rule.
Right.
That rule is generally thought of to, or that time frame is generally thought of to be about 22 weeks. When a baby's 22 weeks old, they're generally considered to be viable outside the mother's womb. Mississippi passed a law that says that abortion can be limited, subject to certain circumstances, at 15 weeks. So in order for the court to uphold Mississippi's law, it is going to have to essentially overturn that viability rule. And that will be a very significant holding. So again, in a nutshell, Mississippi's law says that abortion there's no abortions in Mississippi except for in particular circumstances past 15 weeks. And that's what's before the court right now.
Okay. So obviously the oral arguments have been heard on this and, here in 2021, but the court's not going to rule on this until next year, probably June of 22, correct?
That is correct. Yes.
All right.
Yes.
So tell us a little bit about your role in this Dobbs case and what you think. What did you hear in the oral arguments, and what do you think the court is likely to do?
Well, we've been collaborating closely with Mississippi during the course of the case and helping in a variety of ways. I think in terms of where the Supreme Court is going to land, there's a lot of speculation about that. I think we're hopeful that there are 6 votes on the court to uphold Mississippi's law, to say that a 15-week abortion limitation is constitutional. It's probably no surprise to your listeners that the 3 votes we're all keeping an eye on are the Chief Justice's vote, Justice Kavanaugh, and Justice Barrett, to see where those 3 justices may land. And it looks optimistic in terms of what we heard in oral argument, but you never know until that decision comes down. There's also speculation that there may be 5 votes, possibly 6 votes, to overturn Roe and Casey. And that's really where the court needs to head. Some would say, well, how can you overrule a previous decision that's 50 years old? And others, I think, rightly would say the court gains legitimacy when it recognizes its mistakes, just like it did when it struck down the separate but equal doctrine in Brown versus Board of Education. This is an instance where at this moment in time in our generation, the court has an opportunity to make things right and to return this issue to the states.
Yeah, that's a great point on the Brown versus the Board of Education, because if the Supreme Court had not been willing to overturn a previous decision, we'd still have segregation in this country. And we all know that's not right. That's not who we are as Americans. So talk to me a little bit about what are the implications for states under the various scenarios of what the Supreme Court could do?
Well, the states need to be gearing up. Many states already have. I think Nebraska is working on that as well, to identify in terms of their states how they want to protect life and to support women in the process and to empower women. You know, for so long, women have been pitted against their unborn children, and it's just not right. And so we'll see this issue turn to the states, and the states will be deciding for themselves where they stand on this issue. Some states will protect abortion, and other states will not. And I think it's important to remember, most people don't know this, we have some of the most extreme abortion laws in the world. I mean, we're lining up with one of 6 countries, including China and North Korea, on our abortion laws. So we need to take a good look at this, especially in the light of science. Like 15-week child, they can open and close their hands. They hear their mother's voice. And some would say they even believe that they can feel pain. So I think we need to take a new look at this in light of emerging scientific evidence.
Yeah, so I think one of the implications depends on what your state law is, obviously. Currently, I know that there's some states that have trigger laws that say, hey, if Roe versus Wade is overturned, then abortion is no longer going to be legal in our state. Now, unfortunately, Nebraska does not have one of those laws. but Nebraska, has a law about 20 weeks and so forth. So potentially, we could move that up to 15 weeks if, again, Dobbs, the Mississippi case was upheld, and if it was overturned, then we'd have the opportunity really to, the full rights. If Roe versus Wade was overturned, then every state would have the right to really kind of review it from the beginning. Is that fair?
That is absolutely fair. And Nebraska has been pro-life. I mean, some of the laws it's passed in the last few years, and you as well, Governor, have done such a good job of protecting life and supporting women in that process. So my expectation is that I'm hoping Nebraska falls in line and protects women and supports women and life in this process.
Yeah, we've had some great pro-life champions in our legislature with Senator Joni Albright, Senator Suzanne Geist, who have really worked hard and got some. Actually, we just got the most significant pro-life bill passed in a decade when we ended the barbaric practice of dismemberment abortion, which again gets back to what you were talking about. If we have some of just the worst abortion laws in the country when we're allowing, or in the world rather, when we allow those types of practices.
Yes, and in the 15-week situation as well, it's important to point out that's the most common abortion procedure that takes place when a child is 15 weeks or more. It is that dismemberment procedure, and it's just heinous in what it does to
literally
a
tearing
baby.
the child apart. It's just horrible.
Yeah.
Thank goodness we were able to get that banned here in Nebraska. So the idea then is what you're recommending, at least to different states, is review your laws on the books, see what the implications might be, and then get ready for a variety of scenarios that could come out from the Supreme Court. They could uphold Mississippi's law just on the face of it. They could, as kind of one part of it. Obviously, they could rule against Mississippi. As you said, even with what seemed to be very positive comments from the oral arguments, still be something where they say that they're going to rule against Mississippi, or they could go the other way and could completely overturn Roe versus Wade, and states have to be ready for that.
Absolutely. And they can start preparing now. They can pass laws now. I mean, just as Nebraska has, there were already limitations on abortion in Nebraska. And so all of those laws that have been passed along the way are going to be helpful in this next round. I can tell you ADF is gearing up to stand alongside family policy councils, family policy alliances, state-based groups to help the public understand what's at issue and to help legislators craft constitutional bills as we move ahead. But we're optimistic that the court will do the right thing here.
Okay, great. Is there anything else that we should know about this Dobbs case?
I think it's a case of a generation. I would commend Mississippi in this. When you're sitting in that chair and that burden is on you in terms of what you're going to argue, it takes a person of courage to stand before the Supreme Court and say, you got it wrong 30 years ago, and you sure better fix it. And that's what Mississippi did, and they did it in a compelling way. So my hat's off to Attorney General Fitch and Scott Stewart, the Solicitor General there, who argued that case.
Well, and you actually know from personal experience, having argued cases directly in front of the Supreme Court. Is that right?
Yes.
Well, why don't you talk to us a little bit about that?
At times.
Yeah. Well, why don't you talk to us a little bit about that?
Sure. Well, this last year, actually, we're coming to the end in 2021. We won a case called Uzabunum. It is about a Nigerian college student who tried to share his faith on campus. He was shut down by the university, told that he wasn't in the right speech zone, didn't have the permit that he needed. But the only permit you need to speak on a public campus is the First Amendment, and we all have it. So that case went up to the U.S. Supreme Court, and I had the privilege of arguing it. We won 8-1 in January of this year. And probably the more well-known that I've argued.
Well, I'm sorry, I'm going to stop you there, Kristen.
Sure.
Just talk about that one. So let's talk about that one. So does that mean that, because the University of Nebraska has had the same thing, we're like, okay, well, here's our free speech zone. Here's where you can talk about stuff. And in fact, we had a student from Turning Point USA who had set up a booth to, basically sign up new students for that. Outside this whatever free speech zone the university thought they had set up, and actually it was a professor came over and started verbally abusing her and actually flipped her off and that sort of thing. Was really abused the privilege of being a professor to berate a undergraduate student. And I think what I hear you're saying is that the university doesn't really have the right to be able to do that, to create free speech zones. You can, if it's a public campus, you can speak freely wherever you want to.
There are very limited means that or limited tools that a university has to restrict speech in any way whatsoever. And generally speaking, most universities have policies that are unconstitutional, both in terms of speech zones, meaning where you can speak, and also in terms of speech codes, meaning what you can say. We also see this issue coming up in student fee cases and discrimination based on ideology and religion by universities. The situation that you raise is a situation that we've encountered hundreds of times, and we have over a 90% success rate on the university team because this law is so clear. The problem is, even though the law is clear, university officials won't obey the law unless their feet are held to the fire.
Right.
And we have a case right now against the University of Nebraska-Lincoln involving mandatory student fees, which you issued a statement on as well,
Yep.
saying that it's wrong for the government to put its hand on the scale of free speech and tip to one ideological or one religious side or another.
Yeah. So actually, since you said University of Nebraska-Lincoln, why don't you talk about that one a little bit?
Sure. We represent Ratio Christi. That's a recognized student group on the University of Nebraska's campus. And they requested to have a speaker come on campus and requested that the student union fee provide them about $1,500 to bring that professor on campus. He was a Christian, and Ratio Christi's purpose is to discuss topics and philosophies from a Christian perspective. There are about $280,000 a year that university campus provides to different student groups to bring speakers in. And they denied the request to Ratio Christi, essentially telling them that it was because they were too ideological and religious, and that they could only bring the speaker in if they brought a counter speaker, which they didn't require other groups that were advancing, the opposite viewpoint to do. So that's discrimination. And we're hopeful that the University of Nebraska will change its policy. But if it doesn't, this will go to trial, and I believe will prevail.
Yeah, especially since, it seems like the university has got a double standard here, right? Because if they're not asking other groups to bring in, like, say you've got somebody who's speaking on communism or Marxism or atheism or whatever, and you're not asking them to bring in like somebody to defend the free market system or somebody to defend and talk about religion, they're having a double standard here about it.
Right, and they can't do that. The government can't take sides in a debate. You mentioned the Masterpiece Cake Shop case. That's a little bit about what that case was about, too. There are many cases where the U.S. Supreme Court has said it's not right for the government to take a side in a philosophical battle, and it's not right for the government to silence speech or to compel speech. And there are a lot of ways that the government is trying to do that right now in terms of on the administrative campuses and university campuses. Yeah.
Well, now we've mentioned Masterpiece Cake a couple of times now. Why don't you talk about ADF's involvement in that?
Sure. Well, it was a high conflict case in terms of a cultural moment. It was a case involving a Colorado baker. He began his business.
This is Jack Phillips, right?
Jack Phillips, about 25 years earlier. He named it Masterpiece Cake Shop because he wanted to blend his love for art with his love for baking. And so he became well known for the wedding cakes that he would create. He would hand paint and sketch and sculpt the paints. I mean, it's just beautiful art. Like his cakes are a canvas.
Right.
Over the years, though, from the moment he started it, he said he was not going to be creating messages and cakes that violated his core convictions. So he never did any cakes about Halloween. He was asked to do cakes that would denigrate people, including LGBT individuals, and celebrate divorce. He never did any of those cakes. But when he was asked to design a custom same-sex wedding cake or same-sex ceremony cake, he declined, and that landed him before the U.S. Supreme Court.
Yeah, so talk a little bit about that case and how did that play out in front of the court, and what was the outcome? Just talk a little bit about the kind of the legal arguments in the case. What was Jack Phillips's defense? What were because he was brought, basically it was the Colorado Civil Rights Commission that basically launched the attack on him. And so talk about the case and how that all played out.
Sure. Well, there's a law in Colorado, and we call them SOGI laws. They're sexual orientation, gender identity laws, and they come in under the auspices of preventing discrimination, but they're actually used as weapons against those who would hold traditional beliefs on human sexuality. So that can be traditional beliefs about marriage or traditional beliefs about just being man or a woman, and that it's not possible to transition from one to the other. And Jack got caught in the crosshairs of that battle. The law, Jack serves everyone. Anyone who walks in his shop, he's happy to serve, but he just doesn't create messages that would violate his convictions. And so essentially, when the couple came in, he said, "I'm sorry, I can't design this custom cake. I'll make anything else for you for another event." And the Colorado Commission, basically through the process of the administrative hearing, referred to him as akin to slave owners and perpetrators of the Holocaust, denigrated his faith, and said he would need to shut down his wedding business. And he lost 40% of his income because of their ruling. They also told him that he had to report to Colorado every time he made a decision not to design a custom cake. And I will say, Governor, that, I know Nebraska has, over the last few years, considered laws like these. And Jack came and he talked to some of your legislators, and I think you may have met him as well through this process. But these laws, they sound good, but the way that they're being used is not how they are intended. So it's deeply concerning. In terms of the Supreme Court, we won the case 7-2 on the basis of free exercise, meaning that the government can't be hostile towards someone's faith, and they can't have a double standard. So that's essentially a nutshell of the case.
Now, is this one that you argued in front of the Supreme Court directly, you personally?
I did. Yes, I did argue it in front of the Supreme Court. It's an issue that I care deeply about. I think that not only is it wrong to force people of faith to violate their convictions, but the principle that's at stake here is a core principle that affects all Americans. Perhaps we would design the cake, perhaps we would design the custom flowers, perhaps we would take the custom photographs, but we all have lines, and we should be able to not have to speak messages that violate our convictions. And that's a core principle that we're still litigating, because as I said, in Masterpiece Cake Shop, the court made that decision on the basis of the free exercise of religion, but it didn't touch the free speech arguments. And so there's actually a case pending right now where the Supreme Court may decide to take up that issue.
So before I want to get into a little bit more about, I want to keep going on this Masterpiece Cake thing for a minute, but just tell me a little bit about what was it like for you personally being in front of the U.S. Supreme Court?
It's an amazing experience. I've had the privilege of getting to oversee 12 cases now on my team during my tenure here. And every time it's just a joy to be a part of it. I think most of our cases are not nearly as controversial. That's the most controversial case that we have had. And I would say that experience was very unique. When there are thousands of people outside saying what they want to say, when your client and you are receiving, threats, and just the level of hostility there, but also the privilege of getting to stand beside someone, a client that you is a loving, kind, compassionate individual and it's on the right side, was a great privilege. And I'll just say this, the Uzabunum case I argued was during COVID, so I did that by phone. The experience of being in front of the court, which I had in Masterpiece, was just, again, it was an amazing experience, but very different from being outside the courtroom and doing it telephonically.
Now that's interesting, and I don't want to take us down too much of a rabbit hole here, but doing it telephonically, now you won the case, so it has a happy ending. But it almost seems to me that the Supreme Court look, we know a lot about this virus. There's ways to mitigate the spread of it. By not allowing you to appear in person, they're kind of handicapping your ability to make your case for your client, aren't they?
It was much more difficult. You don't get to read the room. One of the greatest things about being in the courtroom is you feel like you're so close to the justices. You're far more close to them than in other courtrooms. And so it's a very personal experience. For me, in Masterpiece, it was like once you stood at the podium, it was just you and them, and you could focus on that. In the context of doing it by phone, you're not seeing anyone's facial expressions. It's just really a very strange experience. But I will say that they're back in session now. Now, only the attorneys get to go into the court this term. The public doesn't. There's a few media that go in, but at least the advocates are able to argue in person.
At least to be there in person. Okay. So let's get back to Masterpiece Cake then. So the court ruled in your favor, but essentially didn't what they do is they just said, hey, Civil Rights Commission, you are picking on this guy because of his religious values. They didn't really as you mentioned, they didn't address the free speech issues. Is there, and then my understanding is that now Jack is back in court again by the same Colorado Civil Rights Commission coming after him again, this time about, I think it was a transgender person that asked him to design a cake or something like that?
That
sounds like kind of a setup. It sounds like kind of a setup to me, actually.
It was a setup. The Supreme Court moves at its own pace, and sometimes that pace I don't think is as quick as it should be to do justice. And certainly for Jack, that's been his experience, but I'm still hopeful that the court will intervene and protect Jack. What happened was we won on free exercise, and essentially this was Justice Kennedy's last major decision before he retired. And so it was important to him. He had a legacy of ruling a certain way in cases that involved gay and lesbian issues. And so in a sense, it felt like they ducked the free speech issue, but issued a pretty robust ruling on religious freedom. And that ruling has actually been cited over 1,000 times now in different publications and cases involving religious freedom. But we are still litigating the free speech, and it left Jack open. 3 weeks later, the Colorado Commission came after him again, just 3 weeks after it was rebuked by the U.S. Supreme Court. And what had happened there was they doubled down again on hostility towards Jack, making very disparaging statements about his beliefs.
Okay, so that was part of the case, wasn't it? Wasn't that part of the case? Is the language they used to go after Jack in the first place basically made the case that they were hostile and biased in the first when they went after him, and now they went back and did the same thing again?
Yes, they did. And the other thing the court pointed out was that the commission, there was another gentleman who went to 3 different cake shops during Jack's case, and he asked for custom cakes that essentially expressed a negative view of same-sex marriage. And those cake designers declined those requests. And Colorado said that was fine for them to decline, that they had the First Amendment right to do so. They could decline it under the statute, but Jack could not. Jack needed to be punished. And so the court said, you can't have that double standard. So after that clear rebuke, Justice Kennedy wrote the decision, the clear rebuke against the commission, they stepped up again. And the facts are similar to what you said. It was a transgender attorney who called Jack's shop the very day that the U.S. Supreme Court announced it was going to hear Jack's first case. So this is why he called. And in making that request, the transgender attorney said that the transgender attorney wanted to celebrate the attorney's transition from a man to a woman, and wanted Jack to essentially design a custom cake with blue and pink on the inside, blue on the outside. And Jack politely declined that cake. Later, this same transgender attorney called and asked for a cake celebrating Satan, smoking a joint, thinking that might be religious discrimination, I suppose. So it was clearly a setup. During the course of the case, this transgender attorney also said the reason he called was he wanted to force Jack to change his beliefs. Now, as I said, in the course of the litigation with the Colorado...
That forced Jack to change his beliefs? He actually said that on record?
He actually did say that on record, yes. Yes.
That guy belongs like in the Soviet Union. This is America. You don't try to force people to change their beliefs. That's part of what is protected under the Constitution. Unbelievable.
Yes. You're spot on. And the transgender attorney said that the attorney would continue to come after Jack until the attorney won, just demonstrating the intent to harass and to ruin someone because you disagree with their beliefs. So we were able to get that first case resolved because, as I said, Colorado outed themselves. We found in the course of discovery some recordings of statements that they made that they shouldn't have made. But then this transgender attorney filed a third lawsuit against Jack under the same facts. And that case is being litigated in the Colorado Court of Appeals right now. So Jack is continuing to have to fight for his freedom.
Well, this is where the role of organizations such as yours come in place, right? To be able to step in and because, I mean, that's the problem we have with our legal system is that it is expensive, right? So somebody like Jack may not have the legal resources to be able to defend himself, may be forced to shut down his business. And of course, that's a travesty. That harms all of us, and not just people of Christian faith who believe like Jack do, but everybody's diminished when something like that happens because it's harming all of our rights. You may think it's clever that it's if you're a far left progressive and you're coming after you made a guy shut down his cake shop. But what happens when it's you that is in the crosshairs and you're the one that has to shut down your business?
You're absolutely right. And Jack has been a victim of that. We've seen Barronelle Stutzman out of Washington also have to, essentially be subjected to this. We have cases even involving women's shelters where they're on their second lawsuit where these gender identity laws are being applied to deny women their privacy rights in women's shelters. We're seeing these same type of laws being used in different ways to deny women fair play, a level playing field in athletics. And I think we're seeing women being dehumanized in terms of being referred to as birthing people.
Oh my gosh, that's crazy.
So these laws, Nebraska needs to be vigilant about understanding what's at stake, because a lot of times the talking points don't match up to the reality of how these laws play out.
And these are the SOGI laws you're talking about, is that right?
Yes.
Yeah. Okay, great. What are some of the other cases that you mentioned? You had 12 cases that you've argued in front of the U.S. Supreme Court. Are there any others that you want to talk about or mention?
Well, I've had other team members that have argued cases as well while I've been here. Thomas More, Law Center, is one of the more recent victories that we've had. That involves donor right to privacy. There are a number of blue states that have been trying to pass laws that force nonprofit organizations to disclose their donors. And we know what happens when that happens. California, which was the case that this came out of, essentially had leaked information, this donor information. And we see people that are being harassed and, engaging in cancel culture just because certain people disagree with their views. So we were able to prevail in that case. We recently had a NIFLA case that involves pregnancy resource centers whose sole purpose is to support women and save lives. And states have tried to force them to refer for abortion, which is a violation of their free speech rights as well as their free exercise rights. And I would just mention one more. Trinity Lutheran is also a significant win that we're seeing play out right now at the U.S. Supreme Court. Trinity Lutheran involves whether religious organizations can be denied participation in government programs or benefits just because they're religious.
Right.
And we saw that precedent lay the foundation for a case that's at the court right now, which is Carson versus Macon. And that's involving school choice issues, essentially.
Okay, great. Well, I want to stay on kind of one of the things we've talked about with this gender identity. The Nebraska State College System recently clarified that, I'm reading this because it's in quotes here, employees should respect the chosen name and gender identity of other employees wherever possible within the course of college education, business, and communication. So do these types of policies, create concerns from the standpoint of religious freedom and free speech? I mean, we talked a little bit about the SOGI laws that were going after businesses, but here we have it on our state college system where they've created this policy. Talk about some of the implications of that.
Well, you're spot on to note that there are serious implications, and we're seeing them play out on a number of university campuses. We have litigated several of those cases already involving the use of pronouns. Now, the law essentially says that government can't force people to use pronouns. That's compelled speech. A recent Sixth Circuit decision called Merriweather essentially spelled out that even the use of pronouns is a part of a national discussion, national debate that we're having right now about the nature of what it means to be a man or a woman, and that it's wrong for the government to force a professor to essentially articulate one view over another. The Merriweather case involved a professor at Shawnee State who had exemplary reviews, treated all
Shawnee State, is that in Kansas?
Sorry?
Shawnee State, is that in Kansas?
Oh, I got to remember where Shawnee State.
Oh, sorry to put you on the spot there.
It's been so long since I looked. I don't think it's in Kansas. I think it might. I don't know.
Okay.
I'll have to check on that.
Okay. All right. So anyway,
So this professor, he was a longtime professor at Shawnee State. He treated all of his students with great respect, but he declined to use the Ms. or Mr. for a student who insisted that the student be referred to as the opposite sex. The student didn't seem to be presenting as the opposite sex, so the professor wasn't even aware of that. But after the class, the student came up to Professor Merriweather and basically threatened him and said, "You will treat me and address me as a female student or I'll get you fired." And that's pretty close to what happened. The university started to take action against Professor Merriweather, and his case went to the Sixth Circuit. It was an amazingly great decision in that the Sixth Circuit explicitly said, if they can force Dr. Merriweather to use a pronoun that violates his convictions, then it can also force that professor to have to articulate other views that he disagrees with. And Shawnee State University, which is an Ohio university, has since had to come to the realization that
somebody handed you a note that says, "Oh, in Ohio," right?
Like, sorry, we've done it. Yeah, you ruined it. I thought I was going to give you a clean slip. You're good. Well, so Shawnee State University, their case went all the way up to the Sixth Circuit Court of Appeals, and they ruled in favor of this professor. We're also handling a case right now involving 3 teachers in the Loudoun County Public School District in Virginia that's involving a similar policy that you may have heard about.
Is this, well, I know obviously Loudoun County is famous because they allowed a boy to put on a dress and then have access to women's locker rooms or a women's bathroom, and then he sexually assaulted one of the female students there. And of course, that has created all sorts of national. Is that what this case is about?
Well, just before that happened, well, really it happened around the same time, but what first broke in the news was that Loudoun County was considering a policy that would mandate pronouns. It would mandate certain curriculum. It would mandate that boys could enter girls' private spaces and things like that. And there was a teacher who expressed concerns about that policy. The policy hadn't been adopted yet. The teacher simply stood up at a meeting that the school board was considering the policy and expressed his concerns about it and concerns for his students' well-being. And he was immediately suspended, and they were trying to fire him. Thankfully, we won his case, but we're also continuing to litigate on behalf of 2 other teachers the policy itself because of how those policies cause women and girls to suffer the most in denying them private spaces and mandating speech that the government doesn't have the right to mandate.
Yeah. Well, there is a lot that goes on with it. And then again, this is something that we're seeing all across the country with regard to this gender identity and the pronouns and mandating speech and so forth. And I think that it's really interesting that even though you can win a case in court like you have, but if institutions like the University of Nebraska just choose to ignore or flout the law, it has to be relitigated each and every time where it pops up, and you have to have, somebody who is going to stand up and say, "Hey, this is wrong," and really take it to court and have it all play out there to make sure that people's rights are being protected. Is that a fair statement?
I think it is until the decision is well known and there's a penalty to government officials for violating it, they will continue to violate it. But I also think it underscores the importance of people like yourself standing up to protect these freedoms. And it gives other people courage. Courage inspires courage. And if we all succumb to this bullying and cancel culture, we're going to lose in the end. We're going to lose our freedoms, and we're going to hurt human flourishing. So we need people of courage as well.
All right. Are there any other cases that you're keeping an eye on, whether you're involved with them or not? Are there other cases out there that you think are really important for defending our religious freedom, defending freedom of speech?
I mentioned the Carson versus Macon case, which is a case that we're waiting for the Supreme Court to decide. And it follows in kind of a trilogy of cases about educational choice and what kind of programs that government officials can provide to allow parents to make choices that best fit their children's educational needs. I think that's an important decision. Right now, the Supreme Court is also considering whether to take 2 other cases that are ours, including 303 Creative, which is out of Colorado. It's the same law that they tried to apply to Jack that is being applied to a website designer. And the 10th Circuit Court of Appeals, which is right under the U.S. Supreme Court for your listeners, issued a ruling that says the more unique, more powerful that your speech is, the less rights you have under the First Amendment. And that just turns First Amendment law on its head. It cannot stand. And so we're asking the court to reverse it, which will resolve, hopefully, Jack's issue as well and ensure that we all have the right to be able to speak freely. And then lastly, I'll mention one more. Seattle's Union Gospel Mission. It's a case or an issue we're seeing pop up here and there where government officials are trying to force religious organizations to do what they want. And in the Union Gospel Mission, they've said, this is a Washington state case from the Washington Supreme Court, that religious organizations don't have the right to hire people of like faith unless they're only hiring them in a ministerial capacity. And that violates the First Amendment. And I should mention our Biden mandate cases, where the Biden administration is exceeding its authority in trying to force religious organizations and businesses to mandate the COVID-19 vaccine.
Yeah, that's one where they just keep losing and losing and losing, and they don't seem to take the hint that they don't actually have the authority to do this.
Well, sometimes at ADF, we have to reluctantly say we win by losing. And for us, what that means is even if right now those cases are consolidated in the Sixth Circuit, no matter how that Sixth Circuit rules, we believe whether it's a win or a loss, it will go up to the U.S. Supreme Court. And we're hopeful that the court will recognize we have a doctrine called separation of powers, and it matters, and that the Biden administration has exceeded its power in this instance.
So in this instance, when you're fighting this particular case, I mean, I know that for us, one of the things when we're fighting the vaccine mandate, it's really about, hey, the federal government does not have the authority. States could actually do this. My understanding is the state actually has the legal authority to say, hey, I'm going to require a vaccine for whatever reason. But the federal government actually doesn't have the authority to do this. And I think they've actually been caught saying things like they've got a workaround, which I'm like, you don't get to work around the Constitution. So, but they're trying to jam it, for example, with the private employers through OSHA, trying to do it through CMS for healthcare workers and so forth. And that's the one that we're, again, so for our standpoint as a state, we're trying to defend our sovereignty. Is that the same logic you're using when you're taking on your vaccine case there? Or is it a different around trying to protect religious exemptions from that vaccine law or vaccine mandate?
Well, we have 4 different cases, and 3 of them we're actually on the pleadings with different state governments. One of those cases we represent Daily Wire along with Harmeet Dillon, and that's a for-profit entity. And then we're also representing Southern Theological Baptist Seminary, the Southern Baptist Theological Seminary. And that argument has religious arguments to it as well. So I would say, first of all, you're spot on in saying the federal government has limited authority, far less authority than the states have under the Constitution. And not only are they exceeding the authority they have under the Constitution, but also in this OSHA regulation, there are only specific circumstances that can take place in order for OSHA to issue such a broad mandate. And they haven't met those circumstances here. Now, in addition, we would say that there needs to be exemptions for religious institutions because they're impairing their religious autonomy and their religious beliefs. They believe that they need to accommodate the religious convictions of their employees. But I'd agree, too. I want to make sure we point out it's not about whether the vaccine is good or bad.
Right.
It's not about that. And we would say that what it is about is making sure that the government doesn't exceed its authority. Those principles matter.
Yeah, absolutely. I mean, it was one of the things that our founders absolutely understood is that government tended toward tyranny, and you had to have the checks and balances in place to stop that. And that's why they really delegated some powers to the federal government, some to the states, some to the judicial branch, some to the executive branch, some to the legislative branch, really trying to break that power up so that you would have the opportunity to have the checks and balances and really check that tyranny as we saw it. And again, it's just one of those things where we see the overreach of the federal government. This is one of the things that, as the state of Nebraska, we've been working with other states to check it, and not just on this one, but on a number of different ones. And as you point out, there's a variety of ways to do it. Some of it is just on, you don't have the authority, but like with the OSHA case, yeah, they're not even following their own procedures. I mean, you can throw that one out just on procedural matters and say, even if I agree that you could do this, you didn't do it the right way. And so we're throwing it out and you got to start over again.
Right. Process matters. And what we saw, in the beginning litigation and when COVID first started up, we learned a number of lessons. First, we saw how the jurisprudence or the case law that's developed is important because it doesn't just limit it to one situation. So if you allow the government to exceed its authority in one area, that decision translates into other areas. But a second thing I would bring up about the mandate and the COVID, just the response to it, is the importance of our elected officials and being thoughtful and active in the political process. Because as myself, for example, I moved from Seattle to Arizona to join ADF and then moved to Washington, D.C. and in the Northern Virginia area. And I can tell you the difference in those 3 states in terms of how the pandemic was handled couldn't be more different. So who we elect matters. Having good relationships with those that are in authority, it's just critical in all different areas.
Yeah, absolutely. Well, that's a whole other podcast talking about how states handled the pandemic differently. So we're not going to go there. In fact, we're actually kind of running up against our time here. But is there anything else you just want to cover quickly here as we wrap up? Is there anything else that you'd think we needed to talk about we didn't get to?
Well, I don't know of how much interest this is to you, but something that's occupying some of my time right now is focusing on parental rights. And I think you're going to see a trend both in the state legislatures as well as in the courts to take on critical theory and how it is applying. We will be filing some cases. We've got some EEOC matters that are pending right now, because essentially you can't hold orthodox beliefs that all are created equal and teach in some of these public school systems anymore. They're violating the rights of their teachers. They're violating the rights of parents. And so I think that will continue to percolate. And we're also seeing some states propose legislation like transparency in curriculum. So I know we're going to be very involved in that process.
Yeah, not to mention the fact that they are really betraying the whole civil rights movement of the 1960s and Martin Luther King, who wanted his children to be judged on the content of their character, not the color of their skin. The critical race theory is really about resegregation. But again, that's another whole episode. In fact, if you want to listen to Christopher Rufo, I did a podcast with him where we talked a lot about critical race theory. So plugging my own show here. Hey, anyway,
no, I'll listen. I think Chris is great. And again, that demonstrates the power of the alliance, right? We're all in this for different, there are different spokes on the wheel that we fill. And he's done a phenomenal job in educating the public on it and in public policy measures. And we're happy to sue people over it.
Well, good. Hey, well, so we're going to wrap up here, but is there, how can people follow you or follow the Alliance for Defending Freedom? What would be the best way for people to do that?
Sure. Well, Alliance Defending Freedom has ADF Legal on Twitter. They can follow me on Twitter at kwagneradf. Our website is adflegal.org, and they can find out more about us. It's just a privilege to get to serve the amazing clients we do, and I'm so grateful for the opportunity and for all that you're doing for life and for religious freedom and just for standing up for the rights not only of Nebraskans, but setting an example across the United States.
Well, thanks. Appreciate it. Well, thanks so much for being on here. And for our listeners and viewers, you can follow me at @GovRicketts on Twitter, on Facebook. We're on Instagram, pete.ricketts@nebraska.gov. If you want to send an email, please go on and give us a 5-star ranking so that we can go up in the ratings and all that sort of good stuff. I'm not above, shameless self-promotion here. And Kristen, again, thank you so much for being on and telling us more about the ADF. We really appreciate it. And good luck on all these cases where you're standing up and defending our freedoms. I appreciate it.
Well, thank you for having me.
Paid for by Pete Ricketts for Governor, 1610 N Street, Suite 100, Lincoln, Nebraska, 68508.